This is a great question with a complicated answer. Initially, it seems like the application of the Equal Protection Clause to abortion is straightforward because abortion bans only affect people who can get pregnant. But that's actually why this specific ruling can't be used to block abortion bans. This ruling said that bans on gender-affirming treatments for gender dysphoria might be unconstitutional because it makes the legality of those treatments conditional on the sex of the patient. However, abortion bans needn't be conditional on sex. That's not true for gender-affirming care, which includes treatments that are often used in cases other than gender dysphoria. Roe v. Wade was decided under the 14th Amendment right to privacy. Later, Planned Parenthood v. Casey upheld the right to abortion under the 14th Amendment right to due process. The primary difference between the Indiana case and abortion rights that has prevented an equal protection case from being made is treatment versus impact. The Supreme Court's framework for equal protection laws since the Slaughterhouse cases tend to focus on whether the law treats people equally rather than whether it impacts people equally. Anti-abortion laws don't necessarily treat people differently based on sex. It's just that they only apply to one sex. Whether that's right is up for debate, but the precedent exists regardless, and attorneys arguing these cases need to develop an argument that they think is most likely to win, which is rarely the argument most likely to right a wrong precedent. Personally, I subscribe to a theory of the law I think is best described by a legal scholar named Jack M. Balkin, who is a professor of constitutional law and the First Amendment at Yale Law School, which is predicated on the anti-subordination principle, also known as the equal citizenship principle. This principle states, in summary, that a law violates the Equal Protection Clause if it, in effect, creates different classes of citizenship. In this case, bans on abortion put women in a different class of citizenship as men because it limits their rights in ways that it does not men, because it creates an environment where only men have the legal right to not be pregnant. Conservative jurists have long refused to use the equal citizenship principle because it would open the door to all sorts of impact-based equal protection claims against American legal institutions conservatives rely on to maintain relevance and power, like the Electoral College, political gerrymandering, and the Senate. After all, if the law isn't allowed to subjugate people on the basis of that subjugation itself being unjust, then conservatives have a big problem. Never forget, the framers designed a republic predicated on greater rights for the aristocracy, and conservatives exist to maintain that dynamic. When then Senator Jacob Howard of Michigan introduced the 14th Amendment to the Senate in 1866, he described the equal protection and due process clauses as having been designed to, quote, abolish all class legislation in the states and do away with the injustice of subjecting one caste of persons to a code not applicable to another, end quote. However, that's exactly what abortion bans do. People of means in the US can get an abortion regardless of its legality in their state, which means the aristocracy is safe from the impact of abortion bans. Furthermore, abortion bans place a legal burden on women from which men are free. They give the state the power to force women to have children and incur the stress and risks of pregnancy. All arguments claiming that women can avoid pregnancy should they wish involve women necessarily existing and living under different conditions from men. In all abortion cases, the Supreme Court is deciding whether it's constitutional for governments to force poor women to carry pregnancies to term. Doing so provides them unequal protection under the law and relegates them to a lower legal caste from men and women of greater means. That is the most important and justifiable 14th Amendment defense of the right to abortion under the Equal Protection Clause.